And that was the judge saying he stands by this trial, by his previous rulings, the request to vacate the conviction of Jussie Smollett and to order a new trial is denied. And now Jussie Smollett's sentencing hearing will begin, he said, in the next 10 minutes or so. We listened to a lot of argument from Jussie Smollett's attorneys. They claim that his rights were violated on a number of fronts, including the fact, if you'll recall with this case, the fact that Jussie Smollett and his attorneys came to some sort of an agreement with Cook County State's Attorney Kim Foxx, by which he wouldn't be prosecuted. He would just have this deferred kind of prosecution agreement. And then there were people who said, no, I don't think so. This doesn't smell right. The public doesn't have confidence in this. A special prosecutor was appointed by a judge, and the prosecution moved forward from there. This was a case that got a huge amount of attention, nationwide attention. So let's bring our guests in to talk about this. We just heard a lot from attorneys on both sides. Paul Townsend is a criminal defense attorney in New York, and Nima Rahmani is a former federal prosecutor. Thanks to both of you for being here today. Paul, what did you make as a defense attorney of the arguments made by Tina Glangian when she was saying that Jussie Smollett did not get a fair trial? The thing that I thought was really interesting that she tried to bring up was the fact that she said Jussie Smollett had already been punished for this, that there was already a process in place, and then there's the appointment of this special prosecutor who comes in and says, no, we're going to go forward with this case because the public doesn't have confidence in what happened. Do you think that that argument holds any water?
No, but I understand why she made it. When you're a defense attorney, oftentimes you just have to play the cards you're dealt. So that's kind of what you saw with a lot of the arguments that she made. And for anyone who followed this case at all as it was going on, you heard all of those arguments before. They were raised multiple times during the course of the trial. And again, you would expect them to be raised here. You know, you always, as a defense attorney, want to make sure that you have adequately preserved any issue that's necessary for an appeal. So that's kind of a culmination of what she's doing in a post-trial motion for a directed acquittal or for a new trial. You want to make sure that every appellate point that you think came up during the trial or pre-trial is preserved for your appellate review. Having heard her arguments, they're not terribly strong. And I think the judge actually did a very good job at the end of very concisely kind of putting the things to bed. I did think it was interesting to argue about the jury instruction 3.17 on accomplice liability, but that again had already been litigated extensively, and the judge's ruling is fairly coherent, and I think will stand, but not the most compelling argument by Ms. Glandrian, but I understand why she did it.